This criminal defendant has to start behaving appropriately, and you cannot be attacking witnesses on social media and in the public, and it has to stop. And the judge is going to probably be left with no choice, even though he realizes that Mr. Trump may then try to use that politically if he gets put in jail.
No choice but to incarcerate the former president. Nobody sees that happening, really, though, do they?
Well, it certainly could. Is
the Secret Service going to get in the cell with him? How do they do that?
Yeah, I've kind of thought about that some time. I mean, the Secret Service, if he gets convicted on one of the federal charge, Secret Service agents usually go to Florida, after with the president. And the fact they would have to hang out in Leavenworth, Kansas may not have been what they really wanted to sign on for if he gets convicted of a federal charge. But yeah, there's all kinds of logistical problems, and the judge knows this. And that's what he's got to concern. And this is all part of the reason why Donald Trump is getting preferential treatment that no other criminal defendant would get. But at some point, we have to respect the process. And if a criminal defendant is continuing to make public statements that impugn the system, that impugn his own trial and threaten witnesses, calling them sleazebags, which is what he's done here, the court has to step in and do something. And I think the judge is left with frustration at what it would be. Yeah.
I guess it begs the question, to your point, he already has made his feelings about these potential witnesses quite known, calling them sleazebags on multiple occasions. And sure, part of this order was that he has to take down those True Social posts in question or remove a few items from his campaign website. But isn't the damage already done?
Oh, it most certainly is. I think what the judge is trying to do is stop any further damage. So what's to stop then this particular criminal defendant from all of a sudden posting, like he actually has, that this jury is unfair, obviously, and then people start to take matters into their own hands and trying to find out who the jurors are and influence those jurors. Look, you wouldn't put up with a mafia defendant or a, homicidal defendant behaving this way. So you shouldn't put up with Mr. Trump. I mean, if he wants to attain the highest office in the country, he should understand how things work and how the rule of law works. And, I guess the judge would face some frustration. But like I said at the start, I would seriously start considering that. And he's warned Trump about it. And he's going through a very step-by-step process to the point where the judge may have no other choice.
Well, the optics would certainly be historic as we spend time with Robert McWhirter, criminal and constitutional law attorney. Robert, there is testimony taking place today. In fact, we're hearing from Gary Faro, a banker who helped Michael Cohen establish the account that was used to pay off Stormy Daniels. We're going to hear a lot of sensational testimony. We already did, I think, arguably with David Pecker. How important is this business being had today and this week?
Well, it's crucial because it's forming all the steps for the prosecutor to show the underlying crime. I also must say, the prosecution has put on a very smart case. What they have done, and they didn't signal this beforehand, is they have actually broadened this case. It's not just about Stormy Daniels, and it's not just about even Susan McDougal. It's about a much broader conspiracy that Donald Trump entered into to make himself president of the United States by manipulating the media and violating campaign finance. So Stormy Daniels and Karen McDougal and all the other people are just one small part of this broader scheme. And the testimony from Mr. Pecker and the banker today shows the much bigger scheme. I mean, this was not just one bank account used to pay Stormy Daniels. This was a little slush fund that should have been politically reported because it's helping a candidate achieve office. And it's being used for all kinds of little nefarious things, including killing stories and providing payments to people to make sure the stories don't go. And that's what the National Enquirer editor provided. And now the banker is providing the mechanism for how that was done. And it's step by step and much broader. What the implication of that is, okay, go ahead and attack Stormy Daniels. And even if you don't believe her, look at the much bigger picture. She was only one small part. And that's what the prosecution has done.
Well, and ultimately, we don't even know how many witnesses will be called, as they haven't revealed the full list. We also don't know, Robert, if Donald Trump will testify himself. And pardon me, I didn't go to law school, so I don't know if this is an ill-informed question. But would he be limited by a gag order as to what he could say on the stand when testifying in his own defense, or is that actually an opportunity for him to safely plead his case?
Well, first of all, your question is perfectly intelligent. He would not be limited, and that's actually the point. What we try to do with trials is protect the integrity of the process so that you don't have extraneous evidence coming in from tweets and things like that. In a trial, he can take the witness stand and testify as to any relevant thing that relates to this charge. He can say all kinds of things that he is not allowed to say in another public situation, because he will be under oath, he will be subject to cross-examination, and he will be under a process. So he most certainly can. So he is not really being gagged, nor is his First Amendment rights really being implicated, because he will get a chance to speak like any other American who's facing trial, and he will get a chance to give his side of the story.
You wouldn't let him do that if you were representing him, would you?
Well, first of all, a defendant has an absolute Fifth Amendment right to testify. It is their decision, and it is always their decision.
Okay.
If I were his lawyer, I would attempt to sit on him to keep him away from the witness stand for two reasons. One is he is a uniquely bad advocate for himself. And number two, it opens the door for all kinds of what would be called impeachment evidence. So, for instance, if you're testifying, I can bring in evidence that you're just a bald-faced liar. Now, I can't just bring in evidence if you don't testify, because the evidence would go to impeach you. It's not, whether you're a liar or not is not the evidence. It's the fact that your testimony cannot be believed on the matters that are important. So when you testify, it opens the door for all kinds of things legally. So that's, again, one reason. And of course, the first reason is Donald Trump, in every single situation historically where he has testified, he has failed and done very, very poorly. And the jurors do not like him.